Hello and welcome to Counting on Law. The Economic Survey of India lamented that there are 30,600 cases pending in NCLTs across the country. They said that it would take at least 10 years to clear this backlog. The survey goes on to say that we need capacity increases both in terms of judges and infrastructure. However, the budget that came soon after did not indicate any intentions of that in the near future. The capital allocation under the respective head was less than half of what it was last time. But is this cause for despair? We argue it is not. Capacity constraints are always a bottleneck in any developing economy. But instead of lamenting on what we do not have, there are low-hanging fruits that we can reap right now and maximize on the efficiency with what we have. To give an example of this, we did an analysis of a particular case type of cases that appear in front of the National Company Law Tribunal. Section 252 of the Companies Act allows the NCLT to hear appeals on what is known as a strike-off order of the Registrar of Companies. Now, what does this mean? The Registrar of Companies is a key functionary for the operation of the Companies Act of 2013. They keep registers into which the mention of a company's name means the legal existence of the company, and striking off indicates the death and demise of that company. The ROC is empowered to effectuate this death under Section 248. If the company has been inoperational, inactive, etc. for a long time, they may do this on an application by members of the company or may do this suo motu under particular well-defined conditions. Now, if anybody, including the ROC themselves, are aggrieved that the said strike-off was unjustified, they may take it on appeal under Section 252 to the NCLT. These cases are about 35% of all the Companies Act cases that come up to the NCLT, and Companies Act cases alone amount to 40% of the NCLT's caseload. In effect, Section 252 cases are about 12% of the entire caseload of the NCLT. When we examine these cases, however, through the Professeer's database, what we find is that in 9 out of 10 appeals brought to the NCLT, the tribunals reverse the strike-off orders of the ROC. What explains such a high reversal rate? And what does this mean for the functioning of the legislation and, more importantly, for case backlogs in the NCLT? Be examined. 1. In about 40% of these cases, the ROC admits to have struck off the cases mechanically without due manual verification. 2. About 800 of these cases, that amount to a third of the total reversals, are cases which have been filed by the government departments itself. These are mostly the Income Tax Authority or several other authorities which are statutory bodies of the government filing against another government body, which the ROC is. And 3, only in a minimal 10 to 15% of the cases do we really see the NCLT justifying such reversals as on the basis of just and equitable grounds. Now, this raises 3 questions. 1. If 40% of these cases are cases where the ROC admits to its own error, why not allow the ROC to review its own decisions and put the name back in? If the ROC has the power to take it a name from existence, why not give it the power to giveth as well? 2. A third of the litigations of this kind, being government versus government litigations, is appalling. The government fights cases using taxpayer money. The Income Tax Department fighting a case against the Registrar of Companies, both using taxpayer money, with the objective of retrieving taxes from a company that's been taken off existence, is ironic and reeks of systemic dysfunction. Rarely do we ever see the NCLT admonishing either of these bodies for being lax in its duties. The ROC is supposed to send out a notice before it strikes off the name of a company to other statutory bodies, and these bodies are supposed to respond if they have pending dues. In several cases, the ROC admits to having not sent these notices properly or having published in the gazettes properly, and in several other cases, the Income Tax Department admits having received such notices but not having taken action on this. In other words, this has become a fallback option for several statutory authorities that have not done their due diligence, and the NCLT has inadvertently been condoning such cases. And finally, if only 10 to 15% of these cases actually require judicial discernment, why drag the remaining 85 to 90% of cases to the NCLT? Instead, as said earlier, give the power to reinstate the names of these companies and review its own orders to the Registrar of Companies and raise only such matters that really require judicial intervention to the NCLT. In order to understand where the caseload really lies, we have done a bench-wise split-up of these cases as well. We find that Kolkata, New Delhi, and Mumbai have the highest pendency with regards to this particular case type. And a simple legislative change to sections 248 and 252 and the associated rules can, in one fell swoop, clear these cases that amount to about 10 to 12% of the caseload from the backlog of the NCLT altogether. This is especially important given how these cases take about 316 days on average to completion and median 6 rounds of hearings to reach their final outcome. Tying this back to where we started, capacity constraints are a given in any developing economy such as ours. However, while we sit and wait for the budget to take off and for capacity to increase, there are several such low-hanging fruits, the benefits of which we can reap, with this being only one example. Legislative interventions through data-driven analysis is the way to go to maximize on efficiency until we see a robust capacity increase. Thank you.